Hello everybody, welcome back to the Praetorian. Before I get started, I'd like to start off with my usual introductory statement. Thank everybody for listening, and we appreciate all the likes, the subscribes, and we would also appreciate it if you could share these posts. The reason why it's so important to share these posts is because the Praetorian is 100% organic reach. That means that we do not pay for boosts, we do not pay for subscribers or likes. This is 100% organic, and we take pride in that. We wish to bring information to people with as little money involved, make it as free and cheap as possible for everybody. We don't support Patreon and people having to pay for any kind of information in the media that most of the supposed alternative media sources claim that they believe in. So by doing this, we believe that it's actually working on the problem when it comes to internet alternative media, and it's not hiding our heads in the sand. So that's why we do this. So if you could please like, subscribe, and share, we would greatly appreciate it. With all that said, let's continue with the topic. Thank you. Judicial Activist. Judicial Activist describes judicial rulings suspected of being based on personal or political considerations rather than on existing law. It is sometimes used as an antonym of judicial restraint. The definition of judicial activism, in which specific decisions are activist, is a controversial political issue, particularly in the United States. The question of judicial activism is closely related to constitutional interpretation, statutory construction, and separation of powers. Author Schlesinger Jr. introduced the term judicial activism in January 1947. Fortune magazine article titled "The Supreme Court, 1947." The phrase has been controversial since its beginning. An article by Craig Green, An Intellectual History of Judicial Activism, is critical of Schlesinger's use of the term. Schlesinger's original introduction of judicial activism was doubly blurred. Not only did he fail to explain what counts as activism, he also declined to say whether activism is good or bad. Even before this phrase was first used, the general concept already existed. For example, Thomas Jefferson referred to the despotic behavior of federal judges, in particular John Marshall. Black's Law Dictionary defines judicial activism as a philosophy of judicial decision-making whereby judges allow the personal views about public policy, among other factors, to guide their decisions. Political science professor Bradley Canon has posited 6 dimensions along which judge courts may be perceived as activist: majoritarianism, interpretive stability, interpretive fidelity, substance democratic process, specifically of policy and availability of an alternate policymaker. David Strauss has argued judicial activism can be narrowly defined as one or more of 3 possible actions: overturning laws as unconstitutional, overturning judicial precedents, and ruling against a preferred interpretation of the Constitution. Others have been less confident of the term's meaning, finding it instead to be little more than a rhetoric shorthand. Kermit Roosevelt III has argued that in practice, activist turns out to be little more than a rhetoric-charged shorthand for decisions the speaker disagrees with. Likewise, the Solicitor General under George W. Bush, Theodore Olson, said in an interview on Fox News Sunday in regards to a case for same-sex marriage he had successfully litigated that most people use the term judicial activism to explain decisions that they don't like. Supreme Court Justice Anthony Kennedy has said that an activist court is a court that makes a decision you don't like. Detractors of judicial activism charge that it usurps the power of elected branches of government or appointed agencies, damaging the rule of law and democracy. Defenders of judicial activism say that in many it is a legitimate form of judicial review and that the interpretation of the law must change with changing times. A third view is that so-called objective interpretation of the law does not exist. According to law professor Brian Z. Tamanaha, throughout the so-called formalist age, it turns out many prominent judges and jurists acknowledged that there were gaps and uncertainties in the law and that judges must sometimes make choices. Some proponents of a stronger judiciary argue that the judiciary helps provide checks and balances and should grant itself an expanded role to counterbalance the effort of transient majoritarianism, i.e., there should be an increase in the powers of the branch of government which is not directly subject to the electorate, so that the majority cannot dominate or oppress any particular minority through its selective powers. Moreover, they argue that the judiciary strikes down both elected and unelected official actions. In some instances, acts of legislative bodies reflecting the view of transient majority may have had at the moment of passage, and not necessarily the view of same legislative bodies may have at the time the legislation is struck down. Also, the judges that are appointed are usually appointed by previously elected executive officials, so that their philosophy should reflect that of those who nominated them, that an independent judiciary is a great asset to civil society, since special interests are unable to dictate their versions of constitutional interpretation with threat of stopping political donation. Appellate Jurisdiction. Article 3 of the United States Constitution makes the Supreme Court of the United States the highest federal court in the United States. It is ultimate and largely discretionary. Appellate jurisdiction over all federal courts and over state court cases involved issues of federal law. Appellate jurisdiction is the power of a court to review decisions and change outcomes of decisions of the lower courts. Most appellate jurisdictions is legislatively created and may consist of appeals to leave of the appellate court or by right. Depending on the type of case and the decision below, appellate review primarily consists of an entirely new hearing, a non-trial de novo, a hearing where the appellate court gives deference to factual findings of the lower courts, or review of particular legal ruling made by the lower courts, an appeal on the record. Under Article 3 of the United States Constitution, the judicial power of the United States is vested in the Supreme Court of the United States and the inferior courts established by law. The federal rule of appellate procedure governs appellate proceedings. Under its standards of review, an appellate court decides the extent of the deference it would give to the lower court's decision based on whether the appeal was one of fact or one of law. In reviewing an issue of fact, an appellate court ordinarily gives deference to the trial court's findings. It is the duty of trial judges or juries to find facts, view the evidence firsthand, and observe witness testimony. When reviewing lower decisions on an issue of fact, courts of appeal generally look for clear error. The appellate court reviews issues of law de novo, anew, no deference, and may reverse or modify the lower court's decision if the appellate court believes the lower court misapplied the facts or the law. An appellate court may also review the lower judge's discretionary decisions, such as whether the judge properly granted a new trial or disallowed evidence. The lower court's decision is only changed in case of an abuse or discretion. This standard tends to be even more differential than the clear error standard. Before hearing any case, the court must have jurisdiction to consider the appeal. Alright, we have come to the end of our 15 minutes, so I'm going to stop here and I will get back to this later on at a better time. I would like to say again, thank you for listening and have a good night or a good day.